Good morning, everyone. In June, I set out the topics upon which I propose to hear oral evidence in open hearings, namely the interests held and declared by members of the House of Assembly and elected ministers, procurement of contracts, leases, statutory boards, Crown land, belongership and governance, and the law enforcement and justice systems. And I've now heard evidence on all of those topics, including oral evidence in relation to criticisms that arose from the evidence in relation to them. And so the stage of evidence collection, which I began in January, is now concluded. And I'm going to proceed on the basis that the elected ministers, etc., as represented by the Attorney General and her IRU, have now disclosed all documents in relation to these matters that are potentially relevant to my terms of reference. And the same applies to members of the House of Assembly who are represented by Silk Legal. What I'd propose to do is to set some directions for the next stage of the inquiry this morning. And what I'll do is I will go through the directions that I propose with dates, and then go around firstly asking Mr. Rawat and then asking each of the participants for any comments on the proposed directions, including the dates I propose, any of the specific directions I propose, and of course any further directions that might be sought. The evidence stage, as I say, is complete, but that's subject to a number of caveats. First, there are outstanding several requests for disclosure, which we have made to the Attorney General several weeks ago. And I propose directing that the Attorney complies with each of those requests by 4 p.m. on Friday, the 29th of October. The IRU have supplied us with a list, and a full list will be included in the formal order. Second, the Attorney General, on behalf of the elected ministers, has indicated that she wishes to question His Excellency the Governor directly by way of cross-examination, and has reserved her position in relation to applying to question the former Governor, Augustus Jaspert. I've already indicated during the course of the hearings this week that I'm willing in principle to grant the application to question the Governor, and he has said that he is willing to be questioned, but I've yet to determine the topics to which the questions will be limited. In relation to those applications, I propose to direct firstly that by 4 p.m. today, the Attorney notifies the COI of dates of availability for counsel of her choice. I think that is Sir Geoffrey, for the period the 15th to the 26th of November. And whilst I can't guarantee it, I'll do what I can to accommodate counsel. Second, by 4 p.m. on Tuesday, the 26th of October, the Attorney A notifies the COI of the areas in respect of which she wishes to question the Governor, and B notifies the COI if she wishes to question Mr. Jaspert, and if so, the areas upon which she wishes to question him. And thirdly, by 4 p.m. on Wednesday, the 3rd of November, she sends the COI in electronic form a properly paginated and indexed hearing bundle for that hearing. Third, the Attorney has indicated that elected ministers, etc., for whom she acts, wish to file further evidence in relation to the training budget for the public service, and I propose directing that that will be sent to the COI team in electronic form, again duly indexed, by 4 p.m. on Friday the 29th of October. I understand the Attorney also wishes to lodge an affidavit to explain that budget, and I'm content with that by the same time and date, but the affidavit should be restricted to that explanation. Fourth, I was informed yesterday that the Attorney General had received a file from the Auditor General on Blunder Bay, which she was reviewing, and I direct that a copy of that file be lodged electronically with the COI by 4 p.m. on Friday, the 29th of October. Fifth, although I'm proceeding on the basis that all relevant documents have now been disclosed to the COI by the Attorney General in respect of those whom she represents, if I have any specific disclosure requests or queries, then those will be made to the Attorney General as and when they arise. Subject to all of those caveats, evidence is complete. If anyone wants to lodge any further evidence, then they will have to make an application to me, setting out what evidence they now want to disclose and why the evidence was not made available to the COI sooner. In addition to those matters of evidence, a properly formulated application on PII and I understand other grounds in respect of the bundle of documents which the COI prepared in connection with the government's leasing of radar barges remains outstanding. Earlier this week, the IRU indicated that the NSC was still considering that request. In addition, we were told yesterday evening that the NSC wished to consider whether any parts of the transcripts from days 50 and 52 this week, which concerned radar barges, might be subject to a PII application. That at the moment is holding up publication of those transcripts. So I propose directing that if PII or any other ground for non-disclosure is maintained over either the bundle or the transcripts, then a properly formulated application with evidenced reasons for each suggested redaction be made to the COI by 4 p.m. on Friday the 29th of October, failing which I'll proceed on the basis that all of that material can be publicly disclosed. A similar situation arises in relation to those documents annexed to the response of the elected ministers to the position statement submitted by the Governor. That response itself has been published on the inquiry's website. I was unable to publish the accompanying documents as I would have wished until the submission of a properly formulated PII application. So again, I direct that if PII or any other ground for non-disclosure is maintained over documents annexed to that response, then a properly formulated application with evidenced reasons for each suggested redaction be made by the Attorney General to the COI by 4 p.m. On Friday the 29th of October, failing which, again, I will proceed on the basis that all of that material can be publicly disclosed. Many documents have been disclosed to the COI in respect of which the attorney has reserved her position in relation to an application that they are not disclosed or used either at all or further, for example, in my report. That was contrary to the COI protocols, but I have respected that position. However, it does mean that the attorney will have considerable work to do in the near future, and she will have to work at some speed if the report is not to be delayed. As I prepare my report, I shall identify documents to which I propose to refer in the report and identify those to the attorney with a request that any application in respect of PII or any other ground that the document or relevant part not be disclosed be made within a week. That is, I consider, a generous time, but it is intended to give the attorney more than sufficient time to make any application that she wishes to make. It is for her to put in place a mechanism to ensure that any application by those whom she represents wish to make is made in that time. Any application must be properly made, of course, with reasons for each suggested redaction. I will deal with each application on paper. If no proper application is made within that time, then again I propose to proceed to refer to the document or part of the document in the report, and will proceed on the basis that there is no objection to it being made public. At that stage, it will be too late to make an application that the document or any part of it should not be disclosed to the public. In respect of further submissions, first, I have asked the attorney to make written submissions in relation to the scope of Section 13 of the Register of Interests Act, which it is said on behalf of the elected ministers, the registrar breached and the then governor encouraged her to breach. The submissions will focus on the scope of the word information in that section. And I'll make a direction now that the attorney lodges those submissions with the COI by 4 p.m. on Friday the 29th of April. And that if Silk Legal wish to make submissions on that same point, they too do so by that same time and date. Second, I understand that the attorney would like to put in further submissions on her own account on governance following the hearings on governance that we have had this week. Given that in an early, possibly the first hearing that I held, she submitted with some force that she was in some ways responsible for governance. I understand her wish to make those submissions, and I would be happy to receive them by 4 p.m. on the 29th of October. I will limit those submissions to 15 pages. Third, in respect of closing submissions, I propose directing that the attorney and Silk Legal, on behalf of the members of the House of Assembly who are not ministers, shall by 4 p.m. on Friday the 29th of October lodge with the COI a list of matters upon which they would wish to make closing submissions. I will then make further directions as to the topics upon which I would find it helpful to receive closing submissions. The opportunity to make closing submissions, such as I give it, should not be taken as a mechanism to adduce fresh evidence. Any such written submissions, insofar as they're allowed, will have to be lodged by 4 p.m. on Friday the 12th of November. I will then make further directions as to any oral submissions, but if they are needed, then they will be heard, I propose, on the same day as the further questioning of the governor later in November. Those are the proposed directions. First, I think it would be sensible if Mr. Rawat has anything to add or say about those directions before I turn to Sir Geoffrey and Mr. Rowe.
Commissioner, nothing further from me in terms of the directions.
Good, thank you, Mr. Rawat. Sir Geoffrey.
Yes, good morning, Commissioner. Thank you for that. I think our initial reaction is that most of those directions seem perfectly achievable. There are one or two where I would like to request your indulgence for a little extra time. There is quite a lot for us to do by the 29th of October. Looking at the list, the first is the affidavit relating to training budget. As I indicated to counsel to the inquiry, it's a little wider than that, not much, but a little, in that it deals with public servicing budgeting generally and specifically addresses certain initiatives which the governor indicated in his evidence. You may recall he read out a list of initiatives which had been taken in the recent past in connection with reform of the public service. So what we propose is simply to address factually those particular initiatives and the budgets for them, and that will include the budget for training that he mentioned. So it will be a factual presentation, because otherwise I will be asking questions but have no evidential basis upon which to do so. So I'm hoping that will be helpful.
Well, it may be helpful, Sir Geoffrey. I mean, it's not what I had understood, which was purely why the training budget, if the training budget was $25,000, which I understand.
I did, I think, widen it a little in my discussions with council, but it's quite understandable given the time that you've had before coming in. But my application is for a little wider than that, to address the initiatives of which His Excellency the Governor spoke in his evidence the day before yesterday, as well as the budgeting for the public service and public service reform. That includes training. So that's the first point. Now, sir,
Sorry, Sir Geoffrey, can we deal with that? Can we deal with that?
Yes, of course. Yes.
I think in substance, we'll come on to timing too, but in substance, what you'll have to do is you'll have to submit the affidavit that you would like to rely on, and then I'll consider it. To say that, and I don't say this in any way by way of criticism, to say that it is slightly wider than the explanation, than the confirmation that the training budget is or is not $25,000 is somewhat of an understatement. But I would like to see what you would like to say in an affidavit, and then I can consider it. But how long would you like to make that affidavit?
That's my point. I'd be grateful for a week longer than that.
Fine. Stop there,
yes.
Jeff. You can have that week, unless somebody tells me that it would be impossibly inconvenient in some way. But that is fine. I have no problems with that, except to say this. And I know that there's been a great deal of communication, correspondence about this, and references in hearings. But these are dates which it is really important they are met, because they are on the critical path for the preparation of the report, and the time to prepare the report is really very tight. But subject to that, let me see what we'd like to say in the affidavit by Friday the 5th of October, I think.
Sorry.
5th of November.
Sorry, the 5th of November. 5th of November. Okay, yes. Good.
So much then, sir, for that. I'm going, just if I may, through the list, which I took hurriedly while you were speaking. Then there's Blunder Bay. I don't think there's a difficulty with that one, sir. I think we can get to you that. And PII, sir, is a difficulty for us, because I think you've had a communication from the attorney. At the moment, the mechanism is that the PSC has to be consulted. I beg your pardon, the NSC. The NSC has to be consulted, and a meeting awaited. Now, the attorney, I hope, we'll see if we can put in place arrangements to make that a more streamlined procedure. But I am concerned about the Friday the 29th deadline for that, because it will depend on the NSC agreeing to meet, which is currently the procedure that is being adopted. And until it meets, it won't be able to consider putting any other mechanism in place. And I'm afraid I'm just not sure when the secretary and when that will be able to be convened. I'll speak to the attorney today with a view to accelerating whatever can be done to expedite it. But I wonder whether you'd just permit us to come back on that date, subject to the NSC's decision? In other words, when it's meeting?
Well, a couple of things, Jeffrey. Firstly, this in respect of the radar barges bundle, it is long outstanding. It's certainly, I think, from the end of August. I think probably from the beginning of September, but it's been outstanding for a couple of months. The NSC, I think, has been considering this and has considered it twice and come up with different answers. And I'm afraid, and I say this with no disrespect to the NSC at all, but to be told that the attorney simply doesn't know when a response can be given because she doesn't know that the NSC, when the NSC will meet, is a sufficient response for me. The current position with regard to these documents is that there is no application, there is no proper application for PII. Until there's a proper application, there is no PII in existence. And certainly, it seems to me that I've given the NSC more than sufficient opportunity to respond to this. What I'd propose to do, Sir Geoffrey, in the light of your submission, and again, subject to anybody telling me that this is impossible, which I don't think it is to extend the date by a week to the 5th of November. But that, I'm afraid, will be the date. And if it's necessary for the NSC to meet extraordinarily to deal with this important matter, then I'm afraid so be it. But that's the date I'm going to put in the direction.
So be it, sir, and we'll do our best to encourage expedition. What I'm going to ask the attorney is if we can put before the NSC a streamlined procedure for this, so that matters can be dealt with in future, as you've warned us they will have to be. That will
have to be quick. I'm not sure.
I get that. I get that.
I'm not sure that. I'm sorry to interrupt. I'm sorry to speak over Mr. Jeffrey. I'm not sure that many of the matters outside the radar barges will bear upon security. I think most of them will be cabinet matters, but I think streamlined procedure will need to be put in place. Thank you.
Well, one of the things I'll ask the attorney, sir, is if possibly the NSC could be asked to be considered that at the meeting, asked to consider that. Now, so moving on from that, I'm just going through, if I may, quickly. Submissions on section 13, yes. I have no submission on that, but on the attorney's own submissions, I have been asked by the attorney whether you'd be kind enough to grant a further week.
And again, unless anybody starts shouting at me now, yes, I will. Those are, of course, her own views.
Exactly.
But the 5th of November, Sir Geoffrey, yes.
Yes, I'm most grateful. Thank you. As to the rest, I think the next one was you addressed was closing submissions. And by Friday on the 29th, you simply want a list of those matters. I see no difficulty. Well, I see difficulty, but I see no insurmountable difficulty by that, of doing that. And then I think you said by Friday the 12th, you want the written submissions. Am I right about that, sir? I think that's right.
Yes.
And then you'll consider oral. Again, I see no significant, well, again, I see difficulty, but nothing that should be unachievable. So those are my submissions on your dates.
Sir Geoffrey, thank you very much. Mr. Rowe, any submissions in relation to, I think there are one or two matters that where Silk Legal are given, as it were, the directions in relation to any submissions they would wish to make. That's all, I think.
Indeed. Good morning, Commissioner. Good morning, everybody. Commissioner, the dates are satisfactory to us. We'd, however, wish to give one brief legal submission, which we could do by Tuesday next week.
On what? Yes,
I'll tell you what it's about. It is regarding the Seekers Bay project. And it is simply to point out that the Physical Planning Act 2002 was not in effect when the project was approved, that it was the Land Development and Control Act of 1991. But we'll give those in a very short submission to you.
Mr. Rowe, I'll add those into the directions. No problem at all. By 4 p.m.
That's all.
4 p.m. on Tuesday. Thank you very much, Mr. Rowe.
Thank you, mate. Thank you very much.
Any
Just some brief observations. The affidavit that's expected on training budgets. I think the observation I make, it's important that the date of the 5th of November not need to be extended further. And the reason I say that is because if it's going to be put to the governor, he will need, and any legal representative he appoints will need time to consider it, and they may wish to put in other evidence.
Yes.
So
if I may say so, that is precisely why I wanted the affidavit, so the governor could have it in advance of my examination.
Yes, thank you.
In terms of PII, again, one factor to bear in mind is that if it comes to a hearing, we will have to schedule a PII hearing. But hopefully, as is routine, it may be that once the application is submitted, then there can be discussions between the COI and the attorney as to a way forward that will avoid a hearing. And I hope we can have productive discussions of that sort. You've allowed the attorney to submit further thoughts on governance. If obviously you will want, as you have done with other position statements, to publish that. And so it would be helpful if thought is given to it being drafted in such a way that it doesn't need to have redaction or any applications. I think that would be helpful. And I think in terms of the list of matters on which the participants would want to make closing submissions, it would be helpful if there's a distinction being made between factual matters and any legal matters that they wish to address you on.
Yes. Very good. Well, all of those seem to be absolutely fine observations to me. Thank you. We'll draw up a sort of formal order with all of this in and let you have that. I mean, hopefully later today, but certainly in the next day or so. In relation to the hearing, which looks as though it's going to be in the second half of November, then I will assess when we know precisely what the hearing is going to cover in terms of submissions and witnesses and evidence, the most practical way of accommodating that hearing. And I'll let you have details of that in due course in November. Anything else, Sir Geoffrey?
I've had a number of discussions with council. Those are ongoing. I'm sure you will have been briefed on them, but not for the moment, no.
Good. Thank you very much. Mr. Rowe?
Commissioner, no, nothing further to add.
Good. Thank you very much. Well, over the last 6 months, the COI has held over 50 days of hearings of gathering evidence. Although because of COVID, some participants in the hearings, not using that term in the technical term it's used in the COI, but people who have been involved in the hearings have attended remotely. But all of the hearings have been held here at the BVI International Arbitration Centre. And before I close this hearing and this stage of the inquiry, I'd like to thank the CEO of the IAC, Francis LaSalle, and the centre manager, Jeanette Bryn, who have given us tremendous administrative support here and ensured that we have been able to conduct our hearings from here safely during COVID and in compliance with the important restrictions that the pandemic has resulted in. And also vital to these hearings, as will be apparent to anyone who has been watching them, have been Dame Peters, who has been responsible for the audio-visual technology, which has enabled the public to see and hear live at most of our hearings, and also David Kazdan and his team. It's a very, very small team, but David and his team for the live stenography, which has enabled us to publish transcripts of hearings usually on the same day, and the intensity of the hearings has meant that his efforts have at times been frankly heroic, and I'm very grateful to him. I was determined that the COI proceedings should be as open to the public as possible, and Dame and David have enabled them to be so. I'd also like to thank both the public officers who have borne the brunt of the work in responding to COI requests for documents and other information. I understand and very much appreciate the efforts to which they've gone, and also thank the witnesses from whom I've heard, who have made themselves available, in some instances repeatedly, and often in the midst of other important commitments. And finally, I'd like to thank the people of the BVI for their support and their kindness. This COI was established because of their public welfare, and it is being conducted in their interests. But as I say, the support and the kindness that I've received and the COI team have received, again, very, very much appreciated. It has been vital. Good. Thank you all very much. And now I'll close this hearing. Thank you.